an affidavit from Dr. Richard Subran in a separate matter, as well as a trial court order reversing a conviction for a new trial is also as an exhibit.
All right. Any objection from the defendant?
No.
Of those exhibits?
No objection.
Or will receive those exhibits into evidence as State's Exhibits 1, 2, 3, and 4, respectively. Ms. Hall, the clerk is going to need an original non-electronic version of those. So if you can deliver that, I think their policy is within 7 days, but if you can try to get that to the clerk within the next, today or tomorrow, the court would certainly appreciate it.
Absolutely. I have hard copies.
So the court has received those into evidence. Does anyone want to say anything or make any type of presentation on the motion?
Yes, Your Honor. I think both the state and the defense would like to have brief comments.
Yes, ma'am. Go ahead.
Thank you. Again, Teresa Hall for the state of Florida. As you know, Your Honor, we have a conviction review unit at the state attorney's office that Mr. Andrew Warren created in November of 2018. Within that unit, I supervise the staff and the work that is done. Our unit is here to look at claims of actual factual innocence. In September of 2019, Ms. Friedman, on behalf of Mr. Robert Dubois, filed a petition with our unit. We began the process of reviewing all of the documents. This included over 3,500 pages of depositions, trial transcripts, post-conviction motions, evidence, everything that we could get our hands on to review. It moved from what I call an internal investigation to an external investigation when we decided to look at trying to find evidence to test or retest. We also had fingerprints that had been originally found at the scene that Robert was excluded from, but we wanted to enter those into the national database because that database did not exist in 1983. We did that. Those did not come back to anyone from the database. We also wanted to look at the evidence that was admitted at trial. That evidence was destroyed in 1990, so we could not look at any of the exhibits, including the rape kit, that was admitted at the original trial in 1985. We also looked at a very few pieces of items that were still located at Tampa Police Department. They didn't have, in reference to Robert's case, they didn't have any evidentiary value. We then started thinking about where could we find any evidence that might be relevant to this case. Detective Sustek with the Tampa Police Department and I were having a conversation, and he said, well, you might want to check the medical examiner's office. They may have something, and we did. And sure enough, they had the equivalent of rape kit slides in their evidence storage that linked back to the autopsy and the work that was done by the medical examiner's office from Barbara Graham's autopsy. We secured those with the great cooperation of the Innocence Project. We quickly expedited those slides through evidentiary means to a DNA lab, who then processed that DNA within a week, and they were able to conclusively exclude Robert Dubois as a contributor at all. Now, originally, the state's theory of the case was that it was Robert Dubois, as well as his brother, Victor Dubois, and Raymond Garcia that did this crime. Now, Victor and Raymond were never charged, but that was the theory of the case. The DNA also did not come back to either one of those individuals because they do have DNA within CODIS. We had the lab submit the samples that they were able to collect, which included a major and a minor contributor of a male persuasion, and they submitted those to CODIS, and we have now received a positive hit to the major contributor. We're not ready to name who that is. It is now an active, ongoing investigation. But I can say two things. That hit had nothing to do with any of the people that the state suspected. Matter of fact, it didn't have anything to do with anybody that was interviewed or that we even know of from 1983. It also, the hit does indicate that the person does not pose a threat to public safety at this time. We will, of course, talk more about that once our investigation is complete, but that's going to be down the road. So we convened our independent review panel, which we do have for the CRU. That's made up of 3 independent retired judges and justices, Peggy Quince from the Supreme Court, Chris Altenburn and E.J. Salsinas, both from the Second District Court of Appeals. They unanimously agreed that we should seek to immediately release Robert Dubois from prison. We took that information to Mr. Warren, who has the final say, and he agreed with that recommendation. And then we started this process that is before you. I'm going to turn it over to Mr. Warren if he wants to make any comments. And then I know that Ms. Freeman does also have comments she would like for you to consider.
Yes, ma'am. Mr. Warren, anything from you?
Nothing further, Your Honor.
All right, Ms. Freeman.
Thank you. Good morning, The Innocence Project by Susan Friedman for Robert Dubois. I'd like to start by thanking the court for finding time to hear this motion on such short notice. I'd also like to thank State Attorney Andrew Warren and express my sincerest gratitude for Teresa Hall, the supervising attorney of the Conviction Review Unit. We're here today to take the first step in correcting an injustice that started almost 37 years ago. Robert Dubois was only 18 years old when he was wrongfully arrested for the murder of Barbara Grams. His arrest was based solely on bite mark evidence, which has now been discredited. As the state moved toward trial, its only evidence was this bite mark comparison. To build a case, the state turned to a jailhouse informant who had a number of criminal charges pending. Similar to most stories we've heard before, the informant, who had a close relationship with the detective involved in this case, claimed that he received no promises in exchange for his testimony, nor did he expect anything. However, we now know that shortly after a death sentence was secured in Robert's trial prosecutor filed a motion to mitigate the informant's sentence. The informant was originally facing a life sentence, but after testifying falsely against Robert, the informant was released after serving only about 18 months in prison. Robert was just 18 years old. He practically went from high school to death row and spent an unimaginable 37 years incarcerated based on two leading contributing factors of wrongful convictions: incentivized testimony and invalidated forensic evidence. Not only have we uncovered new evidence about the informant, but we also now know that the pattern injury on the victim's face that an odontologist originally said was caused by Robert's teeth was not even a bite mark at all. Robert knew that DNA would vindicate him. And even though he was told over a decade ago that the biological evidence in this case was destroyed, he wouldn't give up. Because of Robert's determination and his strength to keep fighting, we now have indisputable scientific evidence that he is innocent. Robert's fight to overturn this wrongful conviction is not over yet. There is more work to be done, but I am grateful to do this work with Teresa Hall. Conviction review units are important, but even more important is selecting the right person to lead that effort. State's Attorney Andrew Warren did just that when he selected Teresa to head the unit. This was a truly collaborative process. Teresa and I were equally determined to find the truth, and we engaged in a process that allowed us to get there. I'd like to close by saying a few words about Robert. He is kind, patient, and deeply committed to his faith. Even in the most difficult times, he always cared more about others than himself. Today marks the first day that the system is starting to recognize what he has been saying for 37 years, that he is an innocent man wrongfully convicted. Thank you.
All right, thank you, Ms. Friedman. Mr. Miller, anything from you? Right, and anything from anyone else on the agreed motion?
No, Your Honor.
All right, the court, having received the exhibits 1 through 4 into evidence and examined them, and after listening to the presentation of the parties, the court's going to find that the defendant's conviction appears no longer to be supported by fact or law. So I'm going to grant the joint motion. I'm going to amend the sentence in this case, and when I do that, I just want to note that it appears that any sentence in this case would be unjust. But just for the practical purpose of getting him out of prison today, which is the court's intent, I'm going to grant the motion and modify the sentence, and then we'll schedule further proceedings where the court can more closely examine the conviction in this case and have an opportunity for the parties to present further evidence and for the court to consider vacating the judgment and sentence altogether. But for today's purpose, I'm granting the motion, and I'm going to amend the previously imposed life sentence on count 1 to 36 years Florida State Prison with 503 days of jail credit and credit for prison time since March 7th, 1985. Also for count 2, the court's going to amend the previously imposed sentence and sentence the defendant to 15 years Florida State Prison with credit for 503 days in the county jail, as well as prison time since March 7th, 1985. Has anyone done the math on that? Make sure he's going to be released from the day. That's the intent of the court, for him to be released today. So will that credit time accomplish getting him out today?
Yes, Your Honor. Before we entered into this process and submitted this motion, we not only checked the language of the order with the Department of Corrections release staff, but also upon their recommendation, they noted that we should make it 36 years or less so that it leads to his immediate release. And they've approved that for us.
Thank you, Mr. Miller. And that's certainly the intent of the court, is for him to be released today. The court's also waiving all fines and court costs that were previously imposed. Are we ready at this point to schedule a future date, or do we need some more time for that?
Well, Your Honor, one of the first questions I have is, are you able to keep the 3850 motion that will be filed to vacate the conviction?
Yes, that can stay in division rather than go to the post-conviction division.
And then I would ask Ms. Freeman if she would be ready for us to set a date. We do have to write the 3850 motion, but we have excellent templates from various other wrongful convictions in other areas. And so I think we can put that together, but I wanted to ask her how much time she thought she needed.
No, we can do it pretty quickly, Your Honor. So I'm ready to put a date on the calendar.
Can someone suggest a time frame that would be a good time frame for us to have the next proceeding in this case? 2 weeks, a month? You tell me what would be reasonable.
2 weeks would be fine with me.
Is that okay with the state?
Yes.
We find a good date. I have lots of time Friday, September 11th and Monday, September 14th. Either of those are agreeable to the parties. I could schedule it for as long as it needed to be set anytime those days.
Either one of those dates are good for me. Mr. Warren?
I can make either of those dates work, Your Honor.
Ms. Friedman, Mr. Miller, any preference between those dates?
Is it possible to do the 14th, Judge?
Yes, ma'am. Let's do Monday, September 14th, and we'll set it in the morning. Why don't we start at 8:30? Is that okay?
Sure.
Well, I'll block off the whole day, and we'll take as much time as we need to with it.
Great. Thank you, Judge.
Thank you, Your Honor.
If I could, I'm sorry, Mr. Miller, just real quick, in reference to the 3850 motion, this is an unusual circumstance because what's likely going to happen is the defense is going to file their motion, the state's going to file a response, but what you're going to see is that we agree on everything.
Yes,
We're not opposing each other. I guess what I would like to have is guidance from the court of how much evidence, meaning witness testimony, do you want us to actually put on if we are both agreeing to the facts and to the substance?
You know, I think honestly the evidence that came in this morning is could be sufficient. So I don't know how much more direction you want me to give you than that. I mean, that's okay. What the court has already learned is compelling. But I'll listen to any evidence that anyone wants to present. on that day.
So that helps, and Miss Freeman and I can talk about if who we might want to call if we did, and of course, I assume it would be fine with you if they appeared by Zoom.
Yes, ma'am.
All right, I'll let Miss. I think Miss Miller wants to talk to you about the process of trying to get Mr. Du Bois out of prison.
Okay.
Thank you, Ms. Hall. Just a few logistical matters, Your Honor. We spoke with the Department of Corrections Release Management Office in Tallahassee, and they've indicated to us that once Your Honor signs the agreed order that we provided you, the clerk's office will have to prepare the amended sentence and a court verification form for you to sign, and then that gets transmitted by the clerk's office through a secure portal to the Department of Corrections, and then the work in Hillsborough County is done. And so I just wanted to let you know that to make sure that you'll remain available this morning to sign those two documents once the clerk has them prepared.
Yes, sir. I appreciate you telling me that, and I will check my electronic queue, every 30 minutes or so until it's signed. I'll make sure there's no delay on that. I think it's important to all of us that he be released the earliest moment he can be released.
Thank you, Your Honor.
Anything else from anyone? All right. I thank you all for your time participation this morning, and we'll see you again September 14th at 8:30.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Yes, ma'am.
But the only way I can do that, I need to brush